Sarah, it's so great to do this with you. We know each other in industry now because you really have exploded into the scene. You're a great advocate of social media. You've posted lots of interesting advice, and now you are one of the Sunday Times home help columnists. I did that for a while as well, but very well done on that. But
Thank
Sarah,
you.
tell us a bit about yourself, please.
So hi everybody, and thanks so much for having me on, Sharon. It's great to finally be on your podcast, having been a bit of a fangirl for a while. So I'm Sarah Dodd. As Sharon introduced me, I call myself the tree hugging lawyer, and I am the director and owner of law firm Tree Law, which is a newish firm launched in November 2021. So I have 22 years experience now of dealing with claims involving trees. So that's me. And actually, if I could take on a tree as a client, I would do that. So the ethos of the business is really to put the tree.
Yes. Now, I wish I could remember the Latin American country, but there is one where Mother Earth took the government to court over a situation. So I'm going to look into that, listeners, and put that in a LinkedIn post. So taking a tree on as a client, I wonder if that might happen in the future. That's a really interesting thought. Well, we have a lot of international listeners to Tree Lady Talk, so thank you those all over the world. But I'm afraid this one is really just UK law. So that's what we can speak confidently about. But Sarah, aside from your legal background, you're a keen runner as well, aren't you?
I feel like I'm a lapsed keen runner. Yes, I think
Okay.
back in an earlier life, I got into ultra marathon running, but I'm sort of trying to get myself up to running fitness. I think launching a business has been quite overwhelming in terms of time, so I'm trying to find that balance at the moment and fitting those healthy habits back in.
Yep. No, it's very difficult to fit everything in, I know. But let's start off. I mean, what is a tree legally?
Ooh, that's a good question. That it does have a legal definition. I would need to look it up, but it certainly does have a legal definition. You look like you're going to find it.
I am going to find it because I am sitting here with the Law of Trees and Forests and Hedges, third edition, by Charles Miners, Stephanie Hall, and Elizabeth Nichols, by Sweet and Maxwell. It's a great book. It's rather thick and rather expensive, but I'm quite sure you've got a well-thumbed copy on your desk. But aside from what is a tree, which is basically anything one would ordinarily call a tree. So people say to me, is it a tree or is it a bush? Well, actually, it's not that clear, is it? But I bet you get all sorts of inquiries, and I'm going to go back in time now to my long career as a local authority officer, and people say, I love trees, but my neighbour's tree, I hate it. It's growing over my garden, and it's lifting the slabs of my patio. What are you going to do about it? So let's talk about the issues relating to neighbouring trees. What laws are there?
Oof,
So I understand under common
there's
law. What can?
so you could talk about this all day, and I have a lot of
Yeah.
clients who have disputes over boundary trees. So it's a pretty common situation where one neighbour may have a tree and the branches and the roots are encroaching over the boundary onto their neighbour's property, and that neighbour wants to know what they can do, whether that's they don't like leaves dropping, or they don't like birds sitting in there and perhaps pooing on their car. That's something I hear quite regularly. Um,
Yes.
so in terms of the starting position is that as a neighbouring landowner, you're able to remove roots and branches up to the boundary line. But that comes with an enormous caveat, which is that any steps in relation to trees have got to be taken reasonably. So you can't do that if severing the roots and the branches are going to kill the tree. It has to be within that realm of being reasonable, so that has to be done, and arboricultural supervision and advice.
Okay, so that's what we know to be the way to do it. But the layman may not know what is reasonable. And I think we've all seen cases whereby a big mature tree overhangs a garden and the neighbour has cut back the branches to the boundary line and damaged the roots, maybe built a great big building. I've seen this in rear gardens, right up to the trunk of a large tree. Now, often, maybe the person who's done that really doesn't have any arboricultural knowledge, and the law doesn't actually request that anybody, common law does not say anybody cutting back a tree must seek the opinion and advice of a professional person. So this happens quite a lot. So let's take a scenario where somebody comes along, it's a big oak tree, they cut back half the crown, they chomp through the roots to put in, say, an outbuilding, and the tree dies or falls over. Are there many civil litigation cases whereby the owner of the tree takes the person who did the work to court? And what is it like out there legally in that situation?
That's a great question. And I do have quite a few ongoing claims that are within that ballpark in terms of factual scenario. So, yes, I would say over the past 5 years or so, we're starting to see tree owners wanting to take these sorts of claims forward. And pursuing a civil claim against neighbours for the financial value of the damage that has been caused, whether that's the financial value in terms of the loss of value of the trees, the caveat value of the tree, for example, or whether that's as a result of the value of damage that's been caused when the tree has failed.
Okay, so lots of different strands to that. There's a caveat value, that's a financial assessment of the amenity value of that tree. And there might be the cost of having to fully fell that tree or repair anything that might have been damaged. Maybe the tree has fallen on a car or a greenhouse, and also the costs of clearing that up as well. And then, of course, the legal costs themselves. So it could be a substantial claim. Okay, so that is starting to happen. I haven't seen anything about that myself, so I'd be interested in any case law on that. The other thing is
So I was going to say it's quite a new area, and I think if a client was to ring me today and say, I want to pursue this claim, let's full speed ahead, let's do it now, I think it would take about 3 or 4 years for that to actually go all the way through the legal system and come out in a judgment that we could then talk about as a judgment from the court. So I think that given I've noticed probably an increase in clients wanting to do this over the last, say, 5 years, I think we're in that sort of zone of waiting for those judgments to come out so we can start referring to them as, judicial decisions. So we're sort of in that waiting period, I think, at the moment.
Fascinating. Well, I'd be really interested to see that. And there's a few things that the public seem to understand, that you've got to return the wood. So let's say a reasonable amount of pruning takes place. Is it correct in law that somebody can just chop the branches off and then chuck them over the boundary fence? I mean, I think it's rude to do so without offering. And where does that come from?
I think if you were to open the Trees, Forests and Hedges book, it would say, I think, that you should offer it back to them. But I think that comes from just the legalities of ownership. So if the tree is an item that's owned by a neighbour, whilst you might have the right to remove branches that are creating a nuisance, so encroaching from one person's land to the other, the actual item itself still belongs to the neighbour, so you have to offer to give it back to them. Or I suppose in some
equally
situations,
with fallen apples, sorry, I interrupted you. I'm so sorry, Sarah. Sorry.
No.
Do you want to say that last bit again?
I was going to say, but after people have done the branch removal work, I think whilst the formal stance is to actually go and offer it back to a neighbour, but I think there's a lot of chucking it back over the fence.
Yep, and that's literally fuel to the fire in many a neighbour dispute. And what happens to the fruit as well? Let's say you've got a lovely apple tree dropping fruit onto the garden. Who owns that?
That's an interesting one. I don't get involved in fruit very often. I think because fruit doesn't really cause damage, I suppose, unless somebody slips on a rotten apple or something like that. Um, I would imagine, I am sure that one of your listeners may well correct me on this, that actually if an apple, for example, is on an encroaching branch and it falls off and into somebody's garden, that it then belongs to the person into whose garden it's fallen, I would imagine. I'm not sure. I would have
I
to look
think
that
it's
up.
right.
So,
Actually, I think that's right. Actually, so wouldn't it be a lovely, friendly thing to do to go round to your neighbour and say, "Here are your apples in a lovely basket," and everything is rosy in the world. But it's not always like that, is it? Because it's not just the law. It's sort of kind of trespassing, isn't it? This tree, this wonderful tree that's providing all of that beautiful visual amenity, all of those ecosystem services, all of that screening and privacy, but maybe it's a load of really small gardens and that garden's in shade all the time. But there are other things that trees can do, as we know. They can cause damage by direct damage, maybe lifting slabs and cracking brick walls, etc., and indirect damage. So what is a legal position where the neighbouring property is now suffering from cracks in the building? Now, we know that that is a very complex situation, but perhaps you can talk about the legal aspects of investigating subsidence and then remedies for that.
that's a great question, and I think subsidence caused by trees is something that you may or may not, what your listeners may or may not be familiar with. It can depend on where in the country you live and whether you live in an area that's susceptible to subsidence, because it very much needs a few different conditions all to exist together for it to become a risk. And one of those is for a property to be built on a shrinkable soil, which very much the volume of which changes in summer and winter. You know, it shrinks over the summer as it dries out and then expands in the winter as it rehydrates. So one of the key bits of investigative work that you've got to do to work out if a tree is potentially causing subsidence damage is not only finding roots from that tree under the foundations of the damaged property, but also to start looking at the soil itself and see, is that a soil that's susceptible to that sort of volume change? You know, is it a shrinkable clay soil, for example? And depending on when in the year those site investigations are carried out, you know, does that soil show, if it's in the summer, does it show desiccation? So does it show sort of extreme dryness that suggests that roots are actually sucking moisture out of it as the nearby tree grows?
Yeah, that's great. And one of the things about the roots, it's not just the roots that people might think of a big, fat, chunky root. It's a drinking action by the roots, isn't it? So it can be a hair-like root doing all the business of taking water out the ground. And sometimes, you know, trees are the easy, cheap scapegoat, aren't they, for subsidence? It's kind of like has been in the past, perhaps a lazy approach to subsidence, to think that it's the trees what done it, let's get rid of them, as opposed to all sorts of other things it could be. It could be rubbish foundations in the first place, it could be leaky drains, etc. So I know that you are a keen advocate for advising proper investigations. But let's say that there is this seasonal desiccation of the soil in summer and then it re-wets in winter. There's a high water demanding tree such as an oak in the neighbouring garden, and we've established that the soil is a shrinkable soil, clay with a high plasticity index, for example, and the nature of the deformation of the building is such that it clearly indicates all of those factors together indicate that it's a tree. What is the legal position for the affected property with the neighbouring property? And that neighbour may be a local authority, of course. What are the stages and what is the law behind that? We're not talking about TPOs and conservation areas at this stage.
That's a great question, and it can very much depend on what type of tree owning neighbour you've got, whether you've got your, Mr. and Mrs. Jones next door, or whether you've got a local authority as the owner of the tree. In terms of what sort of legal claim you're looking at, again, that's similar to the claim you're talking about with a boundary tree, and it is again a nuisance or negligence claim. There's been quite a bit of change in the law, sort of the legal rules in this area since about 2012, I think it is, because as a negligence claim, there's lots of different steps that you have to tick off as a claimant in order to be able to succeed in a claim against the tree owning defendant. And the one that's really changed in the last 10 years or so is foreseeability. People will probably have heard a lot about, duty of care. You say, oh, my local authority's got a duty of care to make sure that my house isn't damaged. But the foreseeability one is key, which is that a defendant can only be liable for the damage that's being caused by their tree if before that damage occurred, they were able to foresee that that particular tree posed a risk of damage to that particular property. So it's not a generic knowledge, so you can't say, oi, London Borough of whatever, you know that subsidence is an issue in your area. It's not that general knowledge, that general foreseeability. It's very much, could they foresee that particular tree might cause damage to that particular house?
So what might be the circumstances then for, let's say, a local authority having knowledge of that tree, other than so I'm thinking of the practicalities of the overworked tree officer. Do they then have to consider the distance of the trunk to the property, know in minutiae detail the shrinkability of that soil very locally? They'd know the species and they know the size. Does that mean then, Sarah, that said tree officer who is trying hard to meet targets to plant trees, know that the public generally love trees except the ones outside their front door, perhaps if they're causing a problem, that they have to do preemptive felling? And then what about structural heave? Have I got something wrong there? I just think that's quite a burden on the local authority prior to anything actually happening. What does the law say about that?
The law absolutely doesn't want local authorities or any tree owner to do preemptive felling, because you're right, if you were to sort of extrapolate a certain set of rules, these sorts of trees are within this distance from property, they're all too much of a risk and they all need to come down. I mean, that absolutely shouldn't be the rule, because I think even when you have a situation with all of those key things in place, a high water demand tree, a shrinkable soil, a distance from the property, there's still, I think, less than a 5% chance that any tree might cause damage to any property, even in the most subsidence prone areas. So that's absolutely not what the law wants tree owners to do. But I think what the foreseeability element of the negligence test does is it means that really and truly a local authority tree owner wouldn't be able to foresee that their tree might be a risk of causing damage to a property unless there was something particular that put them on notice before that damage occurred that that tree was a risk. And that may well be a past claim. This may have happened in the past, and they may well have committed to doing tree reduction works, which for various reasons might have lapsed over the years. So there could be something like that. Or there are other legal points, such as if the tree and the property is in a well-known hotspot area. So a geographical area where there have been lots of claims in the past. But it's absolutely not crystal clear. So that's one of the reasons why I think local authority tree owners are, I wouldn't say struggling, because there's lots of general issues anyway with budgets and whatnot, but it can be very difficult to put in place the perfect tree management regime across the borough, because you're not going to have a homogeneous state across your borough. Even small London boroughs are going to have areas which are high risk and then areas which are low risk, and actually rolling out one sort of tree management plan across the borough perhaps isn't going to be good enough in one area and is actually too good for another, is above and beyond in another.
So let's go back to Mr. and Mrs. Jones, who have this cherished oak tree. They lived in the house, they got married there, they've been married 45 years, they've raised their family, their grandchildren have played under the tree. It's been a feature of all their garden parties, it's brought them much joy, etc. And now their neighbour is saying, well, the neighbour's insurance company writes to Mr. and Mrs. Jones and say, your tree is causing damage. And Mr. and Mrs. Jones say, no way. What happens legally?
So I think I say this quite regularly, which is the answer to any legal question is it depends, which sounds like a lawyer trying to fudge the answer, but it certainly does depend. I think the worst version of that, which we can see, is when there is a significant oak tree in one garden, which is actually causing damage to a very vulnerable part of the claimant's property, whether that's a poorly constructed extension, whether it's like a conservatory or perhaps a front bay. So an area of the property which is perhaps founded on really shallow foundations and is very vulnerable to damage. So I think when you look at it from the outside and you may see a damaged front bay versus an ancient oak tree, and you think, if you're weighing that up in terms of importance, and I know all of these are sort of quite, I'm talking in quite general terms because there's obviously going to be huge nuances across different claims, but if you've got a front bay which could be demolished and rebuilt on deeper foundations at a relatively a modest expense, versus all of the value of probably an urban dwelling ancient oak tree, then my thought is all steps should be taken to preserve the oak tree and carry out an alternative repair scheme to property. But whilst that's the opinion that I have, and is the opinion that a lot of people have in these situations, often if you see, I think it was a similar sort of situation that person that wrote into the Sunday Times had, really keen to keep the tree versus the damage to the property. The law, unfortunately, the law as it stands is that if a tree is causing a legal nuisance, then the claimant homeowner does have the right to be able to approach the defendant tree owner to abate the nuisance and ask them to stop that tree continuing to cause damage. And the way that you stop a tree, or one of the ways that you stop a tree causing damage, is to chop it down. So unfortunately, the law at the moment does give that as an option.
Okay, well, we know that there are perhaps a few other options. There's root barriers, etc., but we're not going to talk about the technicalities of subsidence in this Tree Lady Talks. But let's go back. Mr. and Mrs. Jones, they get the letter, the tree is causing a legal nuisance which must be abated, and they go, no way. Well, I know, as my experience as a tree officer, occasionally I will be contacted by householders who would ask for a tree preservation order to be served. And I did do that once as well, because I felt that the damage that was being caused was to you put it so nicely, a vulnerable part of a rubbishly put up building, really. And also the tree provided exceptional visual amenity, and we did seek an alternative solution that did stick, actually. But it was a tricky wicket, really, because tree preservation orders have to be reasonable. We'll come on to those later. So that is one option that Mr. and Mrs. Jones could do, which would, at the very least, slow down the process, okay? Because then the local authority is going to say to the insurance company, come on, let's see all the evidence here. The tree is now protected. But at the most, it might stop it and force a different situation. But let's say the local authority say, no, we can't put a TPO on that because it's clearly causing a nuisance. What then if Mr. and Mrs. Jones just say, you can't come onto our land, we're not going to fell the tree? What's the legal situation there?
That's a good question, and often there's other sort of players that come into the mix, because we've got the claimant homeowner and then their neighbouring tree owners, but behind the scenes you're going to have two insurance companies. So you'll have the claimant's insurance company that's gathering all the evidence asking for the tree to be removed and hopefully giving supportive evidence before making that request. But then if you have a defendant tree owner who didn't want to take any action with their trees, they may well be put under pressure to take that action by their own insurance company, because the reason the insurance company might put them under pressure is because if they say no, we're not touching our tree, and as a result of the tree staying in place, the claimant's insurers have to end up spending a lot more money on stabilising the property, usually by doing an alternative such as underpinning the foundations, for example. Then the defendant faces a potential legal claim to recover the cost of that underpinning work from next door. As an insured individual, if you face a legal claim and you receive any legal papers, the first thing you're going to do is contact your insurance company. So where defendants' insurers get wind of this situation and they foresee a potential risk, they think, oh my goodness, if we don't just agree to chop this tree down, we're going to end up facing defending a legal claim of, I don't know, 50, 100,000. It could be very expensive. They themselves can put their own insured under pressure to take that action. So it can almost open a can of worms in that the defendant, not a can of worms, that sounds so negative, but the defendant in wanting to stand by the position and keep the tree could end up finding themselves unsupported financially and having to face a potential legal claim with no insurance behind them. So that is a frightening position to be in.
Yes, I wonder how often that happens. And I wonder also, could the claimant actually have an injunction served to gain access to that property and fell the tree themselves? Is that something that can happen?
Sort of a bit of a mix. So claimants can apply to court for an injunction, which sounds like quite an easy step. And I speak to clients a lot that say, can we get an injunction, or can we get one, or can we resist one? But it's a very expensive step. So obtaining an injunction is asking a court to make an order for somebody on their own land to do something they don't want to do. So judges will tend to see that as a last stop shop. If there's any other solution, then they'll suggest that before actually giving the injunction. But the long and short of it is, yes, courts can give an injunction compelling a tree owner to remove their tree. I think I've been involved in one of those twice or three times over the last 22 years, which I think reflects that it's such an expensive and draconian step to take. Often if you can get the parties together to have a conversation and explore other potential solutions, so solutions which mean both parties can be happy, for example, a root barrier, basically an underground membrane that stops the roots from being able to encroach into next door's ground and underneath their foundations, or other solutions like that, then there's a chance both parties can walk away happy, the tree can stay there and the property can be repaired.
Really interesting. And I wonder also, let's keep with our families here. Mr. and Mrs. Jones, they sell the property, they get on in years, and they get a small bungalow somewhere. And so somebody new moves in and the tree's not protected, it's not in a conservation area. They think, oh, blimmin' hate this tree. I like trees, but I don't like this one. They fell the tree. There's no problems with next door, and yet suddenly there is, a year down the line, they notice structural damage caused by the re-wetting of the soil, structural heave. Are there many cases that you've dealt with or you're aware of, and what might the remedies be? What is the causation and the liability, etc.?
I'm trying to think whether I've been involved in a heave damage case that hasn't gone hand in hand with subsidence. So I don't think I have. So I think that particular factual scenario that you've mentioned, where there's been a change of ownership and the new person that's come in has just said, let's just get that tree out, I don't think I have. I have in terms of like new build estates, for example, where trees have been felled for a new build estate to be built, and perhaps the foundations didn't have the correct sort of anti-heave structure underneath, and then a short while after the houses have been completed and sold on, that they've suffered heave damage. I've been involved in that, I think, and then claims against the house builder, but not very many of those. I think heave damage, I think, is I wouldn't say it's a rarity, but yeah, certainly not something I've seen over the years as often as subsidence, because for heave damage to be a risk, you need in the situation that you're talking about, you need the property when it was built, the property that becomes affected, when it was built, it needs to have been built on a soil which was in a permanent moisture deficit. So you're really needing a situation where the tree is far older than the house and that then later goes on to be damaged.
No, I'm just saying, I'd see it be far less common, because often you'd get the subsidence first and etc. But fascinating. Okay, so let's talk about protected trees. So in the UK, we have fairly good tree protection, but there are it's kind of random at the same time. So just to recap, as you know, we've got tree preservation orders on trees which provide an amenity, which have been picked out by the local authority, which, I don't know about you, but sometimes I find that what people might ordinarily think might be a protected tree locally isn't, because it might not have been under threat. And then we've got conservation areas of the historically important and high value areas of townscape. So let's talk about those two bits of legislation at the moment. Could you just sum up for the listeners who may not work yet in industry what a tree preservation order prevents and the processes to get permission?
Tree preservation orders, I feel like they're a hot topic. I think when I speak in conferences, I feel like I'm always asked about tree preservation orders. And actually it was interesting what you said in your scenario earlier about whether Mr. and Mrs. Jones, who own the oak tree, would actually seek to get that protected by a TPO to really help prevent the need to remove it. And actually that opens an interesting situation in which the parties then expand, and they're no longer just the claimant homeowner and the defendant tree owner, but the planning authority themselves can be involved and can get involved with a legal liability, actually, if they take a step to put a tree preservation order on a tree which is causing. Sorry, I think I've missed your question there.
I wonder. No, that's really, really interesting, Sarah. And I think we're talking about what a TPO stops you doing, basically. It's, it stops you from felling it, pruning it, willful damage, etc. And as a tree officer, I would serve many tree preservation orders. And then you'd have this 28-day period of objection to those orders. I've never come across a local authority yet where an objection led to the TPO not being confirmed. I wonder what your experience is on that. Have you had clients whereby they have instructed you to make an objection to a new tree preservation order on the basis that the tree might be causing a nuisance? Certainly as an arboricultural consultant, I've been asked to do this. The tree isn't worthy of an order because it's quite in ill health or poor structural condition. It really didn't fulfill the criteria for making an order. Have you been involved with cases whereby somebody put together a robust case on why a tree wasn't appropriate for an order, and the local authority has then gone on to say, you know what, you're right? I
haven't been involved in that particular scenario. I've been involved in a couple of different scenarios to that. So I've been involved in one where, or more than one, where a tree owner has said to the local authority, please can you come and have a look at it, please can you put a tree preservation order on it. One that I'm thinking of in London, ancient oak tree in somebody's back garden, which arboriculturalists said they couldn't believe wasn't protected, and yet the local authority, when they came to look at it, decided it didn't warrant a tree preservation order, and that wasn't because there was an outstanding or an ongoing issue with it causing a nuisance. I think it was simply because they didn't feel its amenity value was high enough, because not enough people could see it, because it was sort of in the back garden of a terrace. So I think it was just felt that not enough people could see it. Didn't have a high enough amenity value. But then the flip side of that, and this is a difficult one when you're involved in cases that seem like the polar opposite ends of the opinion on the same sort of factual scenario. It can be quite confusing and difficult to work out actually what is likely to happen, because I think there's such a variance between planning authorities sort of from one area to another. I've been involved recently, for example, in one where there is a very significantly sized tree in a very small back garden that is protected by a TPO, but where the client feels that it's at significant risk of failure, or it's inappropriate. It's an inappropriate size for its location. It's absolutely huge in a very tiny garden, and the planning authority will not consent to any work to it at all. So yeah, that seems from the outside to be two quite similar looking factual scenarios where the planning authorities are taking two quite different views.
Yes, you speak really well then to the matter of subjectivity. So we do have various assessments systems in the UK for making a tree preservation order. Tempo, actually by a friend of the show, Julian Forbes-Laird, which takes you through a process, a scoring system, which actually removes some of that subjectivity. Although my tempo might be different to someone else's tempo, but at least it is an attempt to sort of take a step back. And I too have had very similar scenarios. So as a consultant, I might be working on a proposed development site when there are stonking great, beautiful trees on it, which I think are worthy of an order. I might have a meeting with the local authority, and I can think of loads of cases right now which I can't possibly name, and I think they're worthy of a TPO. So I'll say, well, obviously these trees are really important, we're retaining them, and then the local authority might muse and say, yes, but how can we protect them from the neighbours and the new occupants? There's a risk there. And I'm thinking, well, you could serve a TPO. Again, it's probably a resourcing issues. Where other times there have been some very poor tree preservation orders, including ones I made myself in my early years, where I was just too sort of overexcited and inexperienced, and I think, well, I wouldn't have made that TPO now. That wasn't really reasonable. Because I just think that the word you come across over and over again when looking at legal documents is the word reasonable. And I do think that if you are going to serve a TPO, I mean, I did have a case with a beautiful, mature Wellingtonia in somebody's new garden, which was tiny. I mean, the new building was well within the root protection area, and it had been built, and it just took up all of the garden. And is that reasonable? Isn't that down to poor design in the first place? So I think there needs to be a reasonability assessment. But if somebody does fell that tree, let's give them new names. Okay, Mr. and Mrs. Smith, they move into a new property. It's got a giant Wellingtonia in the back garden. Let's ignore subsidence and heave. And they just think, I've just had enough of this. And they fell it. Then it's a long legal process, isn't it? Tell us about the law and the penalties to do with doing unauthorised work to protected trees.
So in that situation, I presume Mr. and Mrs. Smith haven't made the relevant applications to the planning authority for permission to fell. No, just gone ahead. That is, I'm dealing with quite a few situations that are pretty similar to that at the moment, and I think planning authorities are more and more keen to pursue criminal cases against individuals for felling without permission. Yeah. So those are criminal cases, so criminal sanctions, which can lead up to significant fines, and we're starting to see cases like that hit the headlines. I think again in the last I'm saying 5 years, but not in the recent. It's not in the recent past, but certainly more recent than in the last decade. You are starting to see claims like that going to trial, and then those matters hitting the headlines. So, as a warning, really, to individuals not to take the law into their own hands and do something that without consent and permission.
And there's something else as well, isn't there? Apart from the fines, which are unlimited now in a Crown Court, if it goes to Crown Court, the fact is you'll have a criminal record. And if you are a company director, I don't believe you can be a company director and have a criminal record. Is that right, Sarah?
I think that's right. I think there are other sorts of professions where that's an absolute no-go. So my profession, for example, I'm a lawyer, so I'm part of a regulated profession regulated by the Solicitors Regulation Authority. And I think that would be an absolute no-go. So I could face being struck off if I had a criminal record as a result of illegally felling a tree. So although the fine I might get might only be small or relatively modest, actually the wider implications are something that really could put some people off, which I think people are concerned that the level of fines, although they can be unlimited, can actually seem quite modest. And if you have individuals or house builders or property developers or anybody really who's taking a tree down because they think in doing so they may improve the value of their property, be able to build on land they couldn't touch before, or they've got a great view, or it's no longer in the shade or anything like that, they may think, do you know what, it's financially worth the risk because it's going to increase the value of my property so much, my profit's going to be so big that I'll just suck up that fine because I'm still in profit.
Absolutely, and that is happening. That's happened a lot in the south coast of England, where there's been a lot of high-profile prosecutions where expensive properties looking out to the sea and the trees are felled illegally. I also read in Sydney Harbour that's happening as well, and I actually contacted the tree officer there, and I'm hope to have a discussion with the relevant tree people in Australia soon to follow that up. And friend of the show, Stephen Downing, when he was at Enfield Council, recounted a really interesting case where he'd successfully prosecuted a landowner under the TPO regulations, and we did discuss the fine being relatively small to the potential financial gain. And I still think that is a problem, although it's much better than it used to be. I have prosecuted in my role as a tree officer people in the past, and it took years. And I also remember interviewing somebody under the Police and Criminal Evidence Act, which is part of the process.
Yeah. In
those days, it was done on a tape recorder, and I conducted this interview. I think everybody's nervous. I was nervous. And I forgot to put the tape in. So I had to redo it. But there you go.
They didn't confess in that time, did they, whilst the tape was running around empty?
It was sort of like a 50-minute interview, and then I redid it in about 3 minutes. But anyway, we got there in the end. People's responses to an interview like that vary on their own sort of belief systems. Some don't care, and some are absolutely terrified. But the process is slow, and the local authority has to show it's in the public interest as well, don't they? So I think that is probably becoming easier in the climate that we're in now. I mean, political and social climate, for hopefully, I hope the local authority to make that good case. But most people generally do the right thing, and most people apply. And tell us, though, if somebody applies to, say, fell a tree, and the local authority says no and gives the reasons why, what can the applicant do?
So they can do a few things. Depending on what the reasons are. So if they say no because they haven't been given enough evidence to support the request, then you can go away, gather more evidence and make another application. So that's one option. Another option is appeal the refusal notice, appeal it to the planning inspector, see if you get a different conclusion. And then I think other options after that really depend on what the tree owner wants to achieve. So why do they want to remove the tree? Is it for construction? What reasons is it for? And then exploring potential options around that. Yeah, so that's what I would say.
Okay, and so the appeal process. So I've got a couple running at the moment. In both cases, it's taken a year for the appeal to be even validated by the planning inspectorate. And it will probably take another year for a decision to be made. So it's a very, very lengthy process, and we can't comment why on this podcast. I had another case, which I'm not going to discuss in detail, which my client won, to do with a replacement tree notice in a conservation area, which was involving moving the location of said trees 3 meters from one place to another. That process took 2 years. It's a very long process, isn't it? And let's just leave that there and leave listeners to draw their own conclusions. But I have a couple of questions here for you, Sarah. So in preparation for this interview, I just popped something on LinkedIn, and somebody asked a few good questions here. So it's entirely relating to what we're talking about. He says, are there any changes to legislation that could be made in order to afford trees better protection from developers? The fine for damaging and killing protected trees is nothing much to a developer who's selling houses at, say, £300,000 a pop. Okay, so we could probably both speak to that. But you as a lawyer, what are your thoughts on the protection of trees for development?
I get this question a lot, which is, can't we just change the law? Or what do we have to do to change the law? Where does that need to start? And it can feel like obviously that's such an enormous question, because a change in the law can feel like something that's so obviously wanted, but it's so difficult to do. I think the shortest answer to that is, rather than changing the law, because I think the laws are there to give protection to those trees, is encouraging and emboldening the planning authorities to use the powers that they've got to ensure that where there are breaches, that they do pursue them. They have the capacity and the financial backing to pursue them and to be seen to be pursuing them. So therefore putting off any others from doing a similar thing in the future. So it's a bit of a, not really answering the how do we change the law or is the law good enough. I think it's using the laws we've already got and emboldening those cash-strapped authorities to be able to exercise the powers they've already got.
This is a recurring theme in the podcast, in any conference I attend. It's poor resourcing of local authorities. Well, we have had a change of government, and I wonder if there'll be any changes for the better in terms of local authority resourcing from that change of government. It's only been a few days almost, or just over a week. So we'll see from that. But also, one of the things I'd like to talk about, which is biodiversity net gain. So we had a stonker of an episode last week with Julian Forbes-Laird, and we talked about the potential disparity between biodiversity net gain and the planning policy framework definition of ancient and veteran trees. One of the things that we didn't draw out enough in that conversation because of lack of time is the fact that biodiversity net gain is now mandatory in the UK, majors from February 2024, minors from April 2024, and there shouldn't be any preemptive felling. So I wonder if that is going to actually help with our listeners' question here, is maybe biodiversity net gain is going to be quite powerful in stopping that. What do you think?
Possibly. I haven't come across biodiversity net gain in practice myself yet, and I think that's because, as I was saying to you before, in terms of the timeline it takes for there to be a dispute and get into a legal claim and then come out the other end is quite a while, and that is part and parcel of the Environment Act. And I know that the Environment Act 2021 had some key bits built into it to try and protect trees. So, that's where the biodiversity net gain sits legally, and then also other parts of the law to protect trees, such as the duty to consult. So the law which ensures that local authority tree owners consult with local residents before removing trees that may be implicated in damage. So there are some new bits built in. It's just we're almost in that wait and see time to see, are those actually going to start to work? Like thinking about the duty to consult, for example, the guidance of what local authorities should do to take the relevant steps to consult. That only came out at the beginning of this year, so we're only starting to see actually what does that mean what does that mean practically. So I think perhaps fast forward 12 months time and perhaps we could have some better reflections on whether the law is actually starting to help there.
That's going to be absolutely fascinating, Sarah, and I know that you will help us all with your regular posting on LinkedIn and your excellent blogs with keeping us up to date, and we're really, really grateful to you for that.
You're welcome.
Well, moving on to a different subject. So in the UK, the Occupiers Liability Acts 1957 and 1984 places a duty of care on landowners to do everything reasonably foreseeable to prevent harm from taking place to somebody or something by something that's on that land, i.e. trees. So we have really helpfully in the UK the National Tree Safety Group publications. They've got one for householders and one for landowners, and I think they're really good. I understand they're being reviewed. But in a nutshell, what are the responsibilities? Let's start off with Mr. and Mrs. Jones, whose oak tree, by the way, is in the front garden. I didn't mention that earlier, next to the busy road.
That's a really interesting question. Again, we've spoken a little bit about reasonableness, haven't we, and making sure that you take steps to be reasonable as a tree owner. And I think in terms of making sure that trees in your ownership are safe, it very much depends. No tree is going to be the same as the next one, so it really depends on where Mr. and Mrs. Jones's oak tree is. Is it in a danger zone? So assessing the zone that it's in. If it falls down, is it going to potentially injure pedestrians? Is it adjacent to a pathway? There's a case Whitley, I can't remember the name, it's the Whitley Kavanagh one, where the tree that fell onto a bus stop. So obviously that was in a very high risk area because it's where pedestrians and people getting on the bus would gather and buses would stop. So it really depends on where the tree is. But I think any tree owner within reason should be taking steps to have a look at their tree. I often hear back when there's been a tree failure, for example, and the tree owner may say, well, I'm just an individual, I didn't know it was an issue. But I think individuals are expected, even if they don't pay for an expert or an arbo to go out and have a look around it every now and again, they're expected to walk around their garden, go and have a look at it, just cast an unexpert eye on it and just check. I don't think the law would be kind to you if you had a very obviously dwindling tree in your ownership on a boundary within falling distance of other properties or a path or a road or a bus stop or anything like that and did nothing. I think the law expects you to act reasonably, have a relatively regular-ish, annual, or depending on the sort of risk zone that you're in. And then if there's anything that would put the reasonable person on notice of a problem, then get some expert input.
Yes, so it comes down to, again, another regular theme of every time us tree folks get together, education. And I went to a site yesterday and it was a very large garden, absolutely delightful owner. And the delightful owner said, I don't even ever go down the end of the garden. And there are enormous trees next to the boundary. For some people, it just doesn't impinge on their consciousness any more than taking care of my car impinges on my knowledge, my interest. If there are things I just don't care about, that I don't know about, half the stuff I should do, like, oh God, are we running out of oil? Have you updated this bit of software? What about the tax on the car? I mean, I am so damn lazy when something I'm not interested in. Fortunately, I have in my life the wonderful Noel, who does all the stuff that I just like, yeah, just get on with it, because it's not my bag. And I think there are some people that just think trees, whatever. So, but you, as always with the law, ignorance is no defence of the law. But for those who do know, and maybe they see something that's really quite obvious, and there are gardening programmes on the telly which will talk a lot about gardening, but you don't often see something in mainstream media about what to look for in a tree. I mean, you write for the Sunday Times occasionally when there's a right question. I did that also for a while. But you don't often see something where somebody's walking around a tree going, that's a dead branch, potentially that could fall. This sort of basic information needs to be on mainstream media, and it's not. So I think that is a risk for people. But equally, there is the other extreme of people being super, super cautious and wanting to manicure their tree and and be very fearful. Very, very. We now own a strip of woodland. It's very narrow. It's only sort of 8 metres wide, and it's only about sort of 40 metres long, and it's on an eroding bank. So we're constantly looking and making that safe and taking care of that because I'm super aware of it. But there are all sorts of extremes, and there's been another very good question asked on this matter. Yeah. Let's say the householder or the landowner does engage with an arboricultural consultant. This person asks, would a simple visual tree assessment be classed as a reasonably practical approach to managing tree safety? If a defect in a tree wasn't spotted at the time of the inspection because it was hidden, would it be classed as reasonably practical to have the tree deemed safe at that time? I have an arboricultural view in the answer to that question. What's the legal one?
I think my gut reaction is to say the same thing and say that it depends. I think a visual, and it depends on who's instructing that. If it's the tree owner, it could well be a neighbour that's asking for a survey to be done. There may be restrictions on being able to get access to the tree to have a look at it. But I think more would be expected. The impact of that tree failing were to be higher. For example, I've been involved recently in tree inspections that have been carried out in an area where there was going to be a music festival. So it's going from an area where there wouldn't be much footfall to an area where there are going to be hundreds and hundreds of people all gathered for a significant period of time. So perhaps in a situation in which the risk goes up significantly, that actually more would be expected. But I think I think often with the law, people want a rule. People want, tell me a rule, what's right, what's wrong. And it's just such a sliding scale. So I think in lots of situations, it would be fine. In some situations, it wouldn't be enough. I presume as well in certain situations that doing more intrusive investigations might themselves affect the health of the tree. I presume.
Necessarily. I mean, my thoughts are, as a culturalist, so I carry out visual tree assessments all the time. I'm too scared to climb, so I'd get others to do that. And I no longer have any specialist equipment. So what I do, and I think most of us do, is we do a visual tree assessment. And if there's something which raises a flag, it may be there's beautiful fungus, but it might be doing stuff inside to the tree. And I'm talking about a tree now in what we call a high target area, i.e. if it fell, will it cause harm, rather than a tree in the middle of a forest. And so if there are various factors that lead us to believe there may be something that's affecting the structural integrity of that tree, or it may be so choked with ivy and there's, it's got loss of vitality, and maybe it's a lime, and maybe we think there might be something like Kreutzmaria doyster at the base, which I can't pronounce, folks, I know, but we can't see it because of the ivy tree. Then my recommendation is further survey work is required, such as, tomography, stripping the ivy, an aerial inspection, sometimes a static load test, etc. And there's some wonderful practitioners of all of those things in the UK. So I think, listener, that it's what Sarah says. And also I think that if the VTA in the first place says, does a reasonable assessment and there are no flags raised, well, it will be perhaps disproportionate to look at every single tree and recommend every time tomography, aerial inspection, etc. Because I don't think the law ever asks you to be disproportionate, and in the end it's down to the professional expertise of the investigating arboriculturalist to identify if ever further investigations are needed. That's my thoughts, listener. I don't know if you have anything else to add to that, Sarah.
No, it just reminds me of a factual scenario with a case, and I wouldn't want to repeat it and get it wrong. But again, that was where I think there were some issues with the tree which would have been visible had you been able to get right up to the tree and have a good route around. But I think it was at the back of a garden where it was almost impenetrable and you couldn't get to it. But unfortunately, that tree was along the boundary of a railway line and ended up falling onto the railway line. So that was a very high risk area. But yeah, I should look that up, because that might have a little bit more information in there. If I come up with anything interesting, I will let you know.
That's a really familiar situation to many of us who look at trees. The case I went to yesterday, the garden wasn't maintained, so there were just thickets of bramble everywhere, and it was physically impossible for me to look at the base of those trees. So my recommendation is, at the moment, those trees don't pose a risk to anybody actually, but should the land use change, then the bramble to be removed and then a further inspection carried out. That's how I deal with it. But no, that's absolutely great. I mean, we've actually been talking for a really long time, Sarah. I mean, it's actually about over an hour. So, I mean, I would love to have you on again, because I'd like to talk about trees and planning. I'd like to talk about high hedges, Miscellaneous Provisions Act, Hedgerow Regulations Act, and, the nuances of felling licenses, and also faculties in church. I mean, my goodness me, I had all these questions, but this would go on, I think, all evening. So I would ask you, Sarah, how can people find out more about what you're doing? Because I believe you've got a conference coming up.
That's right. Yeah, thanks for plugging that, Sharon. So I did a couple of conferences last year on tree law, and this year we're going bigger and better. So we have a day-long conference going ahead in London on the 17th of September. So if you want to find me on my social media, on LinkedIn, there's links there to the tickets, and also on my website. But the really exciting thing about this year's conference is it's longer. So we've got some brilliant guest speakers in the morning, including a barrister speaking about Japanese knotweed, which I know isn't a tree, but is a hot topic. I've got Julian Forbes-Laird's going to do a slot, so that's brilliant. I've got some technical other arbos doing slots. Me obviously doing a slot, but what I'm really excited about, in the afternoon we've got a mock mediation session. So it's a chance for people to just sit back and relax and watch us play out what a legal mediation meeting can look like. 'Cause there seems to be a bit of an air of mystery around mediations. They're always done confidentially. They always end with confidentiality agreements. So unless you've been to one, it's very difficult to know what goes on in one. So we're going to bust that myth and show you what actually happens behind the scenes.
And so they can look at your website. Let's just say your website now.
www.treelaw.co.uk. And there is a conference page on there. The tickets are on there.
Excellent, excellent. Well, thank you for that. So finally, Sarah, What is your dream scenario in terms of tree law?
Well, I've been involved in some interesting conversations recently, which sort of takes me back full circle to what I said at the beginning, which was about one day wanting to be able to take the trees on as my actual clients, which I know sounds a little bit quirky and a little bit funny, but I'm speaking more and more to people about what the future might hold in terms of trees having their own legal rights. So not being protected by TPOs or conservation areas or anything like that, but actually having their own legal rights to stop themselves from being damaged. So sounds a bit woo-woo, but watch this space, because I think there's a lot of people pushing in that direction.
How fascinating. And perhaps we can all check out the Mother Earth in Court situation. And well, thank you, Sarah. That's been brilliant. You're a real industry chum. You spoke at my conference, and I very much hope we'll work together in the future. Thank you.
Oh, thanks very much for having me on, Sharon. That's such kind words, and yeah, I've loved meeting you and working with you, so hopefully more of the same in the future.